and Mid-Marketplace PBC LLC.
Good morning. This is Sarah Krajewski on behalf of Defendant Southfield.
Kevin Buchanan, the court appointed receiver, pending appeal.
Everyone's audio is a little quiet this morning, so if you guys could speak up a little bit. So we have one issue that's been set, which is a scheduling order that we need to chat about, and then there's this order on receiver's interim motion for payment of fees. Ms. Shigaris had mentioned there was an issue in the order that I signed last week that she wanted to raise. So we'll address that first about how we want to handle this order and kind of what we want to do going forward. Ms. Shigaris, did you want to raise your, or actually let's hear from Ms. Shigaris, why don't you raise your issues and then we can talk about them.
Thank you, Your Honor. FSG is prepared to pay pursuant to the order Mr. Buchanan's fees today. In doing so, though, we wanted to put on the record what we believe was discussed at the last hearing, which would be if the Court of Appeals reverses the receivership order, FSG will be entitled to get the fees that it's paying today, the $4,103.75, recover that against the bonds that have been posted by the home parties in this matter. And the same would be true if the Court of Appeals affirms the receivership order. The home parties would be entitled to repayment of its portion of the receivership fees from either FSG's bond or payment directly from FSG.
Ms. Pettit.
So the plaintiff voluntarily paid half of the fees, even though we don't think we were, at least going into the hearing, we weren't required to do, but we just did that to try to move this issue along. I've made clear the whole time that we were doing that voluntarily and that we were reserving all of our rights either way. So in that regard, the court's ruling is what it is. If Ms. Shigaris, at least in her emails, has said that they intend to, I guess if I don't enter into some sort of Rule 11 agreement with them, they think they need to appeal your Honor's order. I don't see why the parties can't just, the order says what it says. I don't think that we're required to do anything other than we voluntarily pay the fees. If they need to go file an appeal based on your Honor's order, so be it. There's bonds there. I think the logistics of that is what's confusing. How do you, if you win on this, somehow subtract that from a bond that both parties needed to pay? Like, the logistics of that is just, I think, cumbersome and might be more problematic if it gets entered into a subsequent order. I think it's the most clear to say, look, the court has ordered us to do this. Both parties reserve all rights. Your Honor has not foreclosed the ability for them to attempt to collect that amount from us, or vice versa if the Court of Appeals does one or the other. So I don't know why further complicating the order is necessary. And if they need to appeal it, I don't think that should require me to enter into some sort of Rule 11 agreement.
I would like to stop having quite so many appeals in this case. So I tend to agree with Ms. Shigaris, although I kind of see Ms. Pettit's point. I don't know that it's necessary, but it is what we discussed. If you want to provide an amended order that addresses these issues, again, I'm not sure it's 100% necessary, but if it gives you peace of mind and it keeps you from appealing, as I would say that it should say something like, if this is reversed on appeal, the parties may attempt to get reimbursement on the bond. I don't want to say shall, because I don't know exactly what the Court of Appeals is going to do. If that makes sense, Ms. Shigaris.
Yes, Your Honor. We'll put an order that at least gives the ability to collect from that bond, but is flexible enough if the Court of Appeals does something different.
And then also you can include in there the parties reserve all rights to challenge the payment of these fees or whatever you want to include on that within reason. On that, share that with Mr. Ms. Pettit and Mr. Buchanan, anyone else who needs to review this. I won't be signing any orders probably for about 10 days is my guess. So I'll try to get this signed early beginning of the new year.
Okay, thank you, Your Honor. And given the statements that we've made on the record and that understanding, we'll go ahead and pay Mr. Buchanan today and understand that you'll get the order back after the holidays.
I appreciate that, Ms. Shigaris. And email, once you have an agreed order or some order, preferably an agreed order or agreed as to form order, go ahead and email Rhonda that. And Rhonda, if you could put that on my share for when I come back in to sign orders. Okay. All right. So let's talk about the second order we're dealing with today. Let me see if I can share screen that. I understand there's an issue involving the scheduling order. Is that correct?
I think we've actually been made some progress this morning, and I think at least between Ms. Pettit and I, we have agreed to the order that we submitted with 2 changes.
What are the changes so I can handwrite those in?
Yes, Your Honor. With respect to the first 2 deadlines, the first one, let me just make sure I pull up and tell you the correct dates I calculated. The deadline to add new parties,
Okay.
we've agreed to change that to January 29th.
Oh, that's what
Change it from January 29th to March 1st.
Is that agreed to, Ms. Pettit?
Yes, Your Honor.
Anybody else objecting to that change? Okay.
And then the next deadline, which is the March 1st amended pleadings deadline, we're changing that to March 31.
I'm sorry, which deadline again?
The deadline to amend pleadings.
March 31st. Okay.
And I think with those 2 changes, at least Ms. Pettit's clients and my clients are in agreement on this proposed order. I haven't heard from Mr. Reamer.
And it looks like, just let me get a court has a quick question here. So it looks, and I don't have a problem with this, but I want to make sure I understand what you're trying to do here. And Rhonda, just make sure this is clear on the docket. We're setting both of these different cases for trial on November 2nd. So the Hume case and the 5-Star Global case are both set on November 2nd. Is that correct?
Yes, Your Honor. If you recall, at a previous motion that was filed to consolidate these 2 matters, at the time, Your Honor consolidated them for pretrial, but reserved a ruling for a later date as to whether they should be consolidated for trial purposes. So just to move things along, we've kept them on the same schedule and we've set them on the same day. The Home matter is a jury trial. It needs to be set on the jury trial docket. And the Null matter is a non-jury trial. But we thought as they get closer, obviously we can't try them both on the same day, and one of them will have to get pushed out for trial.
Your Honor, one thing that we need to clarify for that, to move things along, we're agreeing to this proposed scheduling order. We're not in agreement on whether or not the 5-Star Global matter is a jury trial or not. But of course, to move things along, we're signing this, or we're agreeing as to form on this. But I believe there will be additional motion practice later in regard to whether or not this is a jury trial. I just didn't want that to stand in the way of a scheduling order.
Okay. This is the one where there's a jury trial waiver or something, isn't that right?
Yes, Your Honor.
Okay.
Yeah, both demanded a jury. So I guess I'm a little surprised that there's an issue there, but it sounds like we can take that up on a different day.
You said both parties demanded a jury?
Yes, Your Honor.
I think, are you objecting? Are you not objecting? It doesn't matter today. We can deal with this in some future date whenever it comes up. I will say this, November 2nd is probably going to be a non-jury day is my guess. That's going to be election day for 2021. And so, I don't mind keeping it that day. It's just a non-jury day. We can just do pre-trial that day and then do jury selection the next day. If we're doing jury selection by then, hopefully we will be one way or the other, whether it's live or remote or hybrid or whatever we're going to be doing by that point. So that looks fine to me. And anything else we need to chat about today before I let you guys go to enjoy your holidays?
Apparently, Judge, can you hear me, Judge?
Yeah.
Apparently, we're all like indispensable people. We're going to be on the next list for the shot. I couldn't believe it, but okay, I'll take my shot.
Wait, for what's the new thing? I thought it was over 75. I don't think any of us are over
76 or older is the next tranche.
Uh-huh.
And then they go back to quote unquote essential workers, and they put quote unquote legal into that category.
Really? Oh my God.
Yeah, my mother's the one keeping up with all that for me.
Wow. I didn't see that about the legal. I saw about the 75 and over. I'm like, I don't think any of us are 75 or older, but
Close.
wow. Let's get our vaccines then, I guess.
I guess so.
That's great.
Go pick some juries. I'm going crazy.
Yeah, me too. Me too. All right, guys. Well, you guys be safe, and we will see you guys after the holidays.
Have a great trip, guys.
All right, thanks. Bye-bye, guys.
Thank you, Judge Hoffman. Happy holidays.
You too. Bye, everyone.